There's a case where a slug, Thomas Barefoot, with a long criminal record and deserving of the death penalty, escapee from Valencia County Jail in New Mexico, child molester, numerous run-ins with the law, murdered a police officer, death penalty. But it was a case that had a particularly unique legal question in the body of the case. And without going into ad nauseum of the legal question, what it boiled down to was whether or not a hypothetical question could be used of an expert upon which that expert could base his opinion as to the issue of future dangerousness. That was the question. In all past capital cases, the defendant had been interviewed by, say, a psychiatrist or a psychologist or someone in the mental health field. And based upon that determination, or based upon that patient evaluation, that expert was able to give a medical opinion as to whether or not, in his medical opinion, he felt that the defendant would continue to be a threat, which would give the jury sustainable legal evidence upon which to base a death penalty verdict. But those cases, those line of cases, with direct questioning of the defendant by a psychiatrist were overruled. And ruled as unconstitutional because the defendant was not made aware of the right to remain silent on those issues. So that whole line of thinking was, in one fell swoop, at the window. So how are we going to do the issue of future dangerousness? What we did in Barefoot was the psychiatrist didn't go interview the defendant, but we gave the psychiatrist a detailed portrait of the defendant based upon facts that had been admitted into evidence. And based upon those facts, hypothetically ask him, assuming that to be true, what is your medical opinion? And they gave their answer. It was that issue, that one issue, upon which the United States Supreme Court agreed to hear the Barefoot case. So what it did, it removed Barefoot from the body politic of all these cases and made it unique because they had a very, very unique legal question involved that would affect not only the Barefoot case, but virtually every other death penalty case that was tried in Texas and by the United States. So a very unique question, and we argued that case before the United States Supreme Court, I think in 1987. And the Supreme Court said you could do it. It was affirmed, and Barefoot was executed. Now, I don't know today how often it's used, but it's acceptable to do it. I assume it's doing it. I used it in death penalty cases after that. But that's what made Barefoot unique.